Welcome, everybody. My name is Jack Price. I'm a professor here at University of Richmond. You're at the second session of the Everything But the Merits conference. The merits, of course, being the constitutionality of the individual mandate, right? Congress's statement that you must buy health insurance. So this is an Everything But the Merits conference, and the merits are the individual mandate. What will we be talking about? Well, we have people here today that will say litigation over the individual mandate should focus, or at least be cognizant, of three important aspects of that litigation. One would be the remedies that may or may not issue in that litigation. One would be whether or not to approach or to resolve this case using a facial rule or just a holding that applies to the specific case, an as-applied rule. And the third would be the issue of severability. We have three smart people who know a lot about these issues to help us with this today. Professor Kevin Walsh is our local hero on the Affordable Care Act. And, not to say he's a booster or not a booster. It's to say his focus is actually on the remedies, or put this way, how remedies can inform the availability of, inform this litigation in terms of whether it's permissible or not. Professor Walsh is clerked on the Fourth Circuit, then on the Supreme Court, practiced at Hunt & Williams, and now joins us here at University of Richmond for several years. So we're excited to have him with us. Professor Ed Hartnett is the Richard J. Hughes Professor of Law from Seton University. He has written up and down the board on federal courts, procedure, and power. And so we're excited to have him here. He's going to tell us about facial and as-applied challenges and how they connect with this case. Specifically, the court will have to figure out somewhere along in one of these cases, if it reaches the merits, how to resolve the merits, facially or as applied. And then we have Tobias Dorsey. We're also fortunate to have him because he knows legislation, I'd say, pretty well. Not only having written a prominent book on it, a practical book, I might add, but also having served as legislative counsel to the House for many years, and also currently drafting statutes, if you will, or guidelines at least, for the Federal Sentencing Commission. He's going to be talking about severability and how this large statute, if there is one flaw in it, should be considered by the court. So, with that, we'll begin with Kevin.
Thank you, Jack, and thank you to Dean Perdue, all the participants in this panel and the other panels, to the law review, especially Amina Qureshi, who's done so much work, but all of you on the law review, because the work is just beginning, right? Today's a big day. We have the panel, but we've got a lot of editing to come, and that is a plug for the March issue. What you see here, to the extent that I say something that I didn't mean, it will be scrubbed between now and March. That will be the official record. And Seton, speaking of timeliness, I mean, the Supreme Court went to conference on these cases yesterday. We expect an order Monday. It could be relisted. But one thing we can say with almost certainty is that as of March, when this issue comes out, the cases will still be going, likely. So this is just the beginning. So thank you to all the editors of the law review for the work you've done up to today and going forward. And then thank you to everyone who's here to hear about these things. So I'd like to pick up on a thread that ran through the last discussion, which is a sort of focus on the who and the when of constitutional challenges to the individual mandate. So we heard there's some disagreement on the justiciability of state claims, state challenges to the requirement that you maintain insurance. But there has been general agreement that private parties subject to the individual mandate required to obtain and maintain insurance can challenge that requirement at some point. Earlier on in the litigation, there was some dispute about the rightness of these various challenges, but the federal government has taken the position, and the courts have generally accepted that certain private plaintiffs who've already taken some action in anticipation of the insurance requirement going into effect do have standing. Now that gets you your case or controversy under the Constitution, but federal courts also need statutory jurisdiction. And I'm going to focus on the Anti-Injunction Act, which is a limitation on statutory jurisdiction. So there's a few statutes that go by the name Anti-Injunction Act. I'm talking about the Federal Tax Anti-Injunction Act that's in the tax code. So when I say Anti-Injunction Act, that's what I mean. What my goal here is to do three things. Explain what that statute is and the role it's played in the litigation so far. Second, provide a sense of the argument about why there's a reason to think that the Anti-Injunction Act may in fact bar even the private challenges currently pending. And then third, place this act in a broader context, explaining why its presence in the litigation is a good thing, regardless of how the Supreme Court ultimately decides its applicability. And then I'll just conclude by suggesting a possible statutory fix that Congress could consider to preserve these challenges in going forward. Okay, so first, what's the Anti-Injunction Act? Here's what it says. No suit for the purpose of restraining the assessment or collection of any tax shall be maintained in any court by any person. Okay? No suit for the purpose of restraining the assessment or collection of any tax shall be maintained in any court by any person. Why do we have this law? Its purpose is to protect against interference, really, with the administration of the taxing scheme. You can think of it roughly as a pay first, litigate later provision. Okay, you don't get to tangle the government up in disputes you pay, and then you try and get it back. Or you resist paying and let them come after you, and that's when you fight. So how has this played out in the litigation? Well, it played a much bigger role early on. The federal government, by one count, at least 10 district courts, told those courts that the challenges needed to be dismissed because of the Anti-Injunction Act. They said it's a jurisdictional bar. The penalty for not complying with the mandate is something that needs to be assessed and collected as any other tax. And the Anti-Injunction Act would prevent a pre-enforcement suit to interfere with the assessment or collection of that. The effect of these challenges to the requirement, the insurance requirement, is, if successful, would in fact prevent the assessment and collection of a tax. That was at the district court level. They lost across the board. None of the district courts accepted this argument. The judge in Florida, Judge Vinson, really dissected their arguments here, explaining that what the penalty was not a tax at all. And he focused primarily, as did most of the district courts, on the nature of the penalty under the Constitution. That is this penalty, is Congress' enactment of this penalty an exercise of the power to tax? And because that argument lost, it was the district courts that addressed this said the Anti-Injunction Act also did not apply. So these arguments then fell out at the summary judgment stage. There was no need to raise them. On appeal, the federal government changed its position. It explicitly abandoned reliance on the Anti-Injunction Act, noting this in its briefs in the 4th Circuit, the 6th Circuit, and the 11th Circuit. And really attention focused elsewhere. You don't need to be told there's been a lot of the commentariat on these cases has been pretty large. The commentariat was largely silent on the Anti-Injunction Act. And really, in the 4th Circuit oral arguments, which was the first set of oral arguments, this didn't come up at all. Interestingly, the 4th Circuit then issued an order for supplemental briefing in the cases. And that was the first sign, perhaps, that maybe there were some legs to this. But maybe a little bit of commentary, but then commentary moved on. And the 6th Circuit asked about it as well, but it didn't seem to be much of an issue. The game changer for this issue was the 4th Circuit's decision in Liberty University versus Geithner, in which the 4th Circuit, in an opinion by Judge Motz, a split opinion, a dissent by Judge Davis, said that the Anti-Injunction Act blocked even the private party challenges to the Anti-Injunction Act. And the reason that's important is that if the states don't have justiciable claims, which is what the court had held, the Fourth Circuit held in the Virginia case, and if the private parties don't have presently justiciable claims, they're blocked, then nobody does, because those are the two sets of people who are bringing challenges. So if those holdings are both correct, it raises the real prospect that we wouldn't have a resolution on this question that everyone wants answered until, say, 2015, which is when the first set of tax returns for the year 2014 are filed. So the question mattered. The Fourth Circuit did three things that are important going forward. One is it said the Anti-Injunction Act is a jurisdictional bar. So we have to address it whether or not the parties think that it bars the challenge. We have an independent obligation to address it. That's number one. Number two, the Anti-Injunction Act can bar these challenges even if the individual mandate penalty does not constitute a tax under Congress's power to tax. It said that the meaning of tax in the Anti-Injunction Act is broader than the constitutional meaning of tax. And I'll return to that point. But that was something I think largely overlooked. And maybe some would say rightly so because the Fourth Circuit's wrong. I think they're right about that. But either way, this is something that these don't necessarily fit one-to-one. So the federal government might lose on its constitutional power argument, and still this would be barred. The challenge would be barred. And then the Fourth Circuit, third, set forth a pretty broad understanding of what counts as a tax for the Anti-Injunction Act purposes. They said really any exaction, monetary exaction that is administered through the machinery of federal tax enforcement could be a tax within the meaning of the Anti-Injunction Act, then barring some other more precise indicator of congressional intent. In the meantime, by the time the Fourth Circuit had ruled, the Sixth and 11th Circuits had previously ruled. The Sixth Circuit addressed the Anti-Injunction Act, said it's not a bar. The 11th Circuit didn't address it at all. And their matter stood until earlier this week when the D.C. Circuit ruled on the constitutionality of the insurance requirement, and that panel split 2-1 on the Anti-Injunction Act question. Judge Silberman, writing for himself and Judge Edwards and for the court, said that the Anti-Injunction Act was not a bar. Judge Kavanaugh wrote a vigorous dissent on this jurisdictional point, and that's all that he addressed. So as the Supreme Court is going into conference and they're considering what petitions to take, what questions to address, really there's two splits among the courts of appeals. There's a split on the merits, a 2-1 split where the Sixth Circuit and the D.C. Circuit have upheld the insurance requirement, and the 11th Circuit has struck it down. And the other split is on the Anti-Injunction Act. We have a 2-1 split there as well. The Sixth and the D.C. Circuit saying it's not a problem. The Fourth Circuit saying that it is. Okay, so that's sort of the first part. What is it and what role has it played? What can we think about? Why does this matter going forward? Right? Well, nobody knows. Right? We don't, but we can guess. And one, I think, pretty safe prediction is that the Supreme Court has to address it. Now, whether or not they have to address it depends on whether it's jurisdictional. There's been some argument in the cert filings that it's not jurisdictional. I think the Supreme Court is likely to treat it as jurisdictional. And some good reasons include the text of the statute, which says no suit shall be maintained, and also Supreme Court precedent, which says this is jurisdictional. That's older precedent that we can discuss the effect of intervening precedent, but I feel relatively comfortable with that. As to what they're going to do, I don't want to go through all the arguments. What I would like to do, though, is focus on a few points. One is this idea of how the Anti-Injunction Act can apply, even if this penalty is not a tax under the Constitution. And then the other point is how we really can't separate out the mandate from the penalty. And that'll lead into why I think this issue is important, regardless of how the Supreme Court resolves it. So first, warning, I'm about to discuss the tax code. There's a lot of provisions that come in but I read this slowly as I do, and I actually think this comes from Judge Kavanaugh's dissent in the DC case, which I commend to all of you for a very clear discussion, and as well as Judge Motz's opinion in the Fourth Circuit. Read those, then go read the other side, right? There's more to the story. I'm giving you just one side, but here's what Judge Kavanaugh says. He says, the Anti-Injunction Act applies here because plaintiff's pre-enforcement suit, if successful, would prevent the IRS from assessing or collecting tax penalties from citizens who do not have health insurance. To be sure, the Affordable Care Act labels its exaction for failure to have health insurance as a tax penalty and not a tax. But the Anti-Injunction Act still applies. Okay. Now we're going to go through why. So he says that's because the Affordable Care Act requires that the tax penalty for failure to maintain health insurance, and now I'm quoting from the Affordable Care Act, the provision that's at issue. So the tax penalty for failure to maintain health insurance, quote, be assessed and collected in the same manner as an assessable penalty under subchapter B of chapter 68 of the tax code. Okay, pause. So the penalty is to be collected, assessed and collected in the same way as penalties under subchapter B of chapter 68. Step one. Step two. Penalties under subchapter B of chapter 68, in turn, must, quote, be assessed and collected in the same manner as taxes. Okay, so that's it. Now that's from subchapter B of chapter 68. So he then says, and I quote, it follows from those two provisions taken together that the Affordable Care Act penalties must be assessed and collected in the same manner as taxes. Okay, so that's sort of his first premise. He works, so it has to be collected like a subchapter B, chapter 68 penalty. Those have to be assessed and collected as taxes. Okay, next step. Taxes are insulated from pre-enforcement suit by the Anti-Injunction Act. So, in order for the Affordable Care Act penalties to be assessed and collected in the same manner as taxes, the assessment and collection of these penalties likewise must be insulated from pre-enforcement suits by the Anti-Injunction Act. Okay, so that's sort of that's the lead sort of textual argument for why the Anti-Injunction Act applies, and we can see that it's less matters less what label is given it than the instructions that Congress has specifically provided as to how this particular monetary exaction is to be assessed and collected, and the Anti-Injunction Act and the Affordable Care Act both speak directly to that issue. Okay, so there's more that one can say. Just laid out one of the arguments. Again, it's a minority argument in the Court of Appeals. If we're counting noses in the Court of Appeals, only 3 judges have accepted a version of this argument. 6 have rejected it. If you're sort of going in sort of ideological terms, you're just trying to predict, this is one that's cross-cutting. This is not something that breaks down on party of appointing president or generally perceived ideology in the Courts of Appeals, really on either side. Judge Silberman and Judge Davis have very different sort of approach to things as to Judge Motz and Judge Kavanaugh. And so this is lawyer stuff where they're disagreeing over the really close and difficult issues that require close attention. Okay, I don't want to belabor the point. Read the things. There's a lot more to be said. I do want to focus, though, on one move that the challengers have made that I think is particularly interesting to get around this. And that is to say that we're not challenging the penalty. We're just challenging the mandate, right? Those are two. So provision A, here we go. What is challenged is one section of the code, 5,000 cap A, like big A. So 5,000 cap A has several subsections, A through G. A is the initial part of what's called the individual mandate, right? Every applicable individual shall have minimum essential coverage, and so on. B is where we start getting into the penalties, and they say, look, we're just challenging really 5,000 cap A subsection A, something like that. So what was this? If that's right, then the penalty falls out, and it doesn't matter how it's supposed to be assessed and collected, and we just get right to the mandate. So it's a powerful argument if it works. I think there's three problems with it, and I'll run through those quickly. One is the statutory problem. I think that this section is really an integrated, interwoven whole. You can't really separate out subsection A, so that's sort of a severability point. But so think about this. Subsection A of 5000 Cap A, it says each applicable individual shall have minimum essential coverage. Well, who's an applicable individual? You have to look at subsection D to figure that out. What's minimum essential coverage? You got to go to subsection F to figure that out. If you say, well, the tax penalties are distinct, well, if we look at subsection B, it talks about, well, you get a penalty if you haven't followed subsection A. You have all these internal cross-references, and there's more sort of as a statutory matter. So subsection E has an exemptions from paying the penalty, and that says no penalty shall be imposed under subsection A. Well, if subsection A is the thing that's entirely separate from the penalty, Congress apparently didn't get the message because they say that the penalty, no penalty shall be imposed under subsection A. What they mean is A together with B, this whole thing. Subsection G1 says the penalty provided by this section. That would be 5000 Cap A, the whole thing. So it's just a statutory argument. There's also a second problem, which is precedent. I won't belabor this because there's a dispute over the meaning of this precedent, but the Supreme Court has held in Bob Jones' case and Americans United case. Well, here's what Judge Kavanaugh drew from those cases, and again, you can assess it. This principle that if the only sanction that attached to a federal law that regulates private behavior is the imposition of a civil tax exaction that falls within the coverage of the Anti-Injunction Act, then the Anti-Injunction Act applies. And absent an exception precludes a pre-enforcement suit. So you can't go after the trigger alone without, if the effect is to invalidate the penalty, then the Anti-Injunction Act applies. That's precedent. Last point on this is a justiciability issue. A naked mandate challenge, by which I mean a mandate challenge just considered entirely apart from enforcement, I'd say it runs into a potential case or controversy problem. So think about it this way. Imagine, that there were no penalty. Imagine that the law said every applicable individual shall have minimum essential coverage, but the law said we're not going to keep track of who does and who doesn't, and you should feel really bad about yourself if you don't have insurance coverage. Well, sir, it says you shall have it, and the penalty is you shall feel really bad. Could you go into federal court? What would your remedy be? In order to make me feel better, buck up, buddy, because in fact they don't have that power. So I think that there's a serious point as to what it is that a court does when it orders a remedy, and that it's orders, say, an injunction, like don't do this to that person, right? Don't take money from this person. You have no legal authorization to do that. And so I do think there's a important conceptual distinction between the requirement and the penalty that enforces it. But I don't think we can think about a remediable injury apart from actual or threatened enforcement of something against somebody. So we can come back to that if needed. Okay, why is it good for this issue to be in the case? Well, in part because of what I just said. It reminds courts of what they're supposed to do. We're not asking courts for a thumbs up or a thumbs down on the mandate. We're asking them to decide whether a particular law is enforceable against a particular set of people. And I think it also helps us focus on what is the unit of analysis. So it's curious that in the mandate challenge, on the one hand, they're saying the whole law has got to go because of severability. On the other hand, they say we're just challenging this thing, not even the penalty, just the mandate, and it raises some serious issues that perhaps we'll save for question and answer about how to characterize these things. And last point, since I'm out of time, is Congress can fix this. They can pass a law that would preserve even the ongoing challenges. They can give jurisdiction, make an exception if they want, and make that retroactive to these pending cases. With that, I'll turn it over to my co-panelists.
Once upon a time, the law governing facial constitutional challenges was simple to state. There's a general rule and a First Amendment exception. As the Supreme Court put it in United States v. Salerno, it had not recognized an overbreadth doctrine outside the limited context of the First Amendment, and that in all other contexts, a facial challenge could only succeed by showing that no set of circumstances exist under which the act could be valid. The First Amendment exception enabled the challenger to show that although his own conduct was not constitutionally protected, the statute was written sufficiently broadly that it also applied to others whose conduct was constitutionally protected and therefore could not be constitutionally applied to anyone. Outside of the First Amendment, the notion was, unless a litigant could meet the stringent test for a facial challenge, he could only mount an as-applied challenge, one that would be successful only if the statute was unconstitutional as applied to him in his circumstances, and one whose impact would be similarly limited. If all he could show is that the statute would be unconstitutional as applied to some hypothetical other, his challenge would fail, the statute would be enforced against him, and the possibility that some hypothetical other might have a legitimate constitutional claim would be left for another day. This seemingly neat doctrine began to give way under analytic pressure. Perhaps not surprisingly, the first pressure point on the Supreme Court involved abortion. Justice Scalia and Justice Stevens sparred over the application of the Salerno test to abortion cases. Eventually, in an abortion case, the court concluded that even there, the court should try to limit the solution to the problem, preferring to enjoin only the unconstitutional applications of a statute while leaving the other applications in force, and acted on this statement in Carhart 2, rejecting a facial challenge to the federal statute banning partial birth abortion, leaving to later litigation the possibility that it might be unconstitutional as applied in some situations. With the spotlight turned on the issue of facial challenges, it became more and more clear that the simple statement of a general rule with a First Amendment exception was deceptively simple, if not downright wrong. The decisions holding federal statutes unconstitutional for exceeding congressional power under the Commerce Clause were decisions of facial invalidity. Some, but not all, of the cases finding that Congress exceeded its power under Section 5 of the 14th Amendment were treated the same way. The Booker decision held that the federal sentencing statute was facially unconstitutional for violating the Sixth Amendment right to a jury trial. Over the years, scholars demonstrated that facial challenges are more common and more successful than the court itself acknowledged. And in an article published this summer, Professor Richard Fallon makes a powerful case that even the prior scholarly critics have understated the point. Based on his count, he contends that in the Supreme Court, facial challenges are not only more common than as-applied challenges, but also have a higher success rate. He argues that if you look at a survey of leading cases across a broad range of constitutional provisions, you'll see that the court has held statutes wholly invalid under nearly every provision of the Constitution under which it has adjudicated challenges to statutes. Despite the confusion that's inherent in a situation where there's such divergence between the oft-stated rule and the actual practice, I nevertheless think there are three things that can be stated as clear about facial versus as-applied challenges. First, regardless of whether a judge in a particular case describes his holding as facial or as applied, the actual impact of that decision will depend more on the permissible scope of any injunction, the law of preclusion, and the law of precedent. Imagine, for example, a district judge dismissing a federal indictment on the grounds that the statute relied upon in the indictment is unconstitutional on its face. That decision prevents the government from prosecuting that defendant under that statute, but it has no power under the law of preclusion to prevent the government from prosecuting a different defendant. Nor does it under the law of precedent bind any judge in higher courts, other district courts, or even judges in that same district. The judge may describe the ruling as one of facial invalidity, but the statute lives on. Not only lives on in the statute books, as statutes do until repealed, regardless of what judges say about them, but also in actual operation. On the other hand, imagine a decision by the Supreme Court of the United States holding a statute unconstitutional as applied, but based on reasons that apply to all, or virtually all, actual applications of the statute. The court may describe its holding as one the court may not describe its holding as one of facial invalidity. It may describe it as a holding of as-applied invalidity. But the law of precedent will make it effectively, or nearly so, the same as a holding of facial invalidity. The second thing that I think is relatively clear here, I think more than relatively clear, I think that is clear about facial and as-applied challenges, is that the distinction between facial and as-applied challenges represents a continuum, represents a range rather than two nice, neat, dichotomous categories. The Supreme Court's decision in Bernie, I think, is the classic example of that, or at least a classic example of that. In that case, the Supreme Court held that the Religious Freedom Restoration Act exceeded congressional power under Section 5 of the 14th Amendment. Its decision wasn't tied in any particular way to the facts of that case. It hardly mattered that the case involved a claim that application of local land use law to a planned expansion of a church violated RFRA, as opposed, for example, to a claim that application of a state drug law barring the consumption of peyote violated RFRA. That is, it seems like the Bernie decision was a decision that RFRA is unconstitutional on its face, not simply as applied. And to a very large extent, it is. Under Bernie, RFRA cannot constitutionally be applied to state and local government action. But nothing in the reasoning of Bernie calls into doubt RFRA's validity as applied to national action. As to that, Congress need not rely on the 14th Amendment. This point, that facial versus as applied invalidity is really points on a spectrum rather than two nice neat dichotomous categories, and the explanation for that, turning on the reasons given for a particular holding, leads to the third point that's clear in this area. That is, whether a statute is held unconstitutional on its face or as applied turns to a considerable extent on the substantive constitutional doctrine that's brought to bear in a given area of the law. Consider the Establishment Clause. To the extent that the court relies on the Lennon test and determines that a statute lacks a secular purpose, the statute's unconstitutional on its face. The particular application of the statute doesn't matter. Consider on the other extreme the limits imposed by the Due Process Clause on personal jurisdiction. The minimum contacts and reasonableness tests of International Shoe and its progeny look to the particulars of individual cases. So whether you wind up with a facial decision or as applied decision turns in large part on what substantive doctrine you're applying. I've argued that this third point should lead us to another. That is, instead of treating substantive doctrine as given, whatever its impact on producing determinations of facial or as applied validity or invalidity, courts should consciously shape substantive constitutional doctrine with an awareness of the extent to which that doctrine will tend to produce judicial decisions that decide the constitutionality of the statute on its face. And because I believe that courts are, in general, better suited to adjudicating on an as-applied basis, I think that courts should, in general, shape constitutional doctrine in a way that tends to produce as-applied judicial decisions. I admit this may seem a rather abstract point, and certainly once doctrine is in place in any given area, there may be considerable reluctance to refashion it in this way, given the general path dependency of a legal system with a doctrine of precedent. What does any of this have to do with the Patient Protection and Affordable Care Act? Well, as we've heard, of course, the central issue on the merits is whether the individual mandate is within congressional power under the Commerce Clause. And in keeping with the premise of this symposium, I'm not going to discuss the merits themselves, but rather discuss the extent to which the merits might be approached on an as-applied as opposed to a facial basis. Conceitedly, existing Commerce Clause doctrine is hardly hospitable to as-applied adjudication. The modern cases finding violations of the Commerce Clause, Lopez and Morrison, were determinations of facial unconstitutionality. The aggregation principle of Wickert, which calls for the impact of individuals' behavior to be added together in order to find substantial effect on interstate commerce, pulls strongly away from as-applied challenges. The court has repeatedly stated, most recently in Reich, that where the class of activities is regulated, and that class is within the reach of federal power, the courts have no power to excise as trivial individual instances of the class. And Reich itself upheld the federal prohibition on marijuana, rejecting the argument that the statute was unconstitutional as applied to medical marijuana patients largely outside the interstate drug market. In these circumstances, it's hardly surprising that some think that there can be no such thing as a successful as-applied challenge based on the Commerce Clause. So certainly in light of all this, you have to concede that odds are that the Supreme Court, if it reaches the merits, will either find the individual mandate constitutional on its face, following cases like Wickert and Reich, foreclosing the possibility of as-applied challenges, or, because we're not talking about the merits, or find it unconstitutional on its face, following cases like Lopez and Morrison, and foreclosing the possibility that it could be constitutionally applied in some instances. But not necessarily. The court is being called upon to make new law. As Judge, whichever way they go, they're being called upon to make new law. As Judge Silberman put it, the mandate is indeed somewhat novel, but so too, for all its eloquence, is the appellant's argument challenging the mandate. Right? From the perspective of the challengers, the defenders of the statutes are asking the court to endorse a dangerous new principle, and from the perspective of the defenders, the challengers are asking the court to impose a new, heretofore unheard of limitation on congressional power. The novelty of whatever the court does here puts it in a better position, should it so choose, to formulate the new doctrine in a way that takes into account how that doctrine will affect the availability of facial as opposed to as applied challenges. And Judge Sutton has put the issue on the table, showing how it can be done. This is of considerable importance because the court has admitted that it sometimes overlooks the possibility of insisting on as-applied determinations if the parties seek all-or-nothing determinations. Judge Sutton's concurring opinion in the Thomas More Law Center case concludes that the ACA is constitutional on its face while holding open the possibility that as-applied challenges might succeed. He explains that there are at least 4 settings in which the individual mandate can constitutionally be applied, and that this is enough to preserve the statute from facial invalidity. He acknowledges that some theories of invalidity necessarily apply to all applications of a law, and therefore don't lend themselves to as-applied adjudication. But he contends that other theories, and the ones in this case, that is, the proposed action-inaction limitation on congressional power, that theory does lend itself to as-applied evaluation. As he sees it, if a court were to accept some variant of the idea that Congress may not, under the Commerce Clause, regulate inactivity or force people to enter a market they choose not to enter, if the court were to accept that on the merits, that new doctrine could be applied on an as-applied basis, and that nothing in his view upholding the constitutionality of the statute on its face would preclude such as-applied challenges as the relevant agencies implemented, as the lessons taught by the particular prove or disprove that Congress crossed their constitutional line in imposing the unprecedented requirement, and that justice courts should refrain from needlessly prejudging the invalidity of the laws in any applications. They should refrain from doing the same with respect to their validity. I think he's right. I think Judge Sutton is right that the challengers' theories, at least as generally articulated, the challengers' theories lend themselves to as-applied adjudication. But I also think that there's more ambiguity to this point than his opinion suggests. To my mind, reflecting on his opinion, that leads me to think that it's not only that substantive constitutional doctrine affects the availability of facial versus as-applied challenges, but that the very same substantive constitutional doctrine can sometimes be conceptualized and articulated in two different ways. One way that leads toward facial evaluation, or one that leads toward as-applied evaluation. And I think the court should be self-conscious about how they conceptualize and articulate the doctrine one way or another. That is, although some doctrines lend themselves readily to facial determinations, and others lend themselves readily to as-applied determinations, some can be described in more than one way. I think you can see that in Eighth Amendment doctrine. I think you can see that in due process limitations on personal jurisdiction. I think you can see that in the Carhart case. That in some ways that's what divides the majority and the dissent in Carhart itself. That is whether they conceive of the constitutional principle as one that has to be reflected in the text of the statute. So if it's not reflected in the text of the statute is invalid on its face, or whether the constitutional principle simply limits how far a statute can go, such that it cannot be applied past that constitutional limit. If one can articulate the same standard in multiple ways, there's a choice between how to conceptualize and articulate it. Just one example to make the point. Think about the prohibition under the Eighth Amendment of executing those who are minors when they committed the offense. You could conceptualize that as a rule that says a statute that doesn't contain that exception is unconstitutional on its face. And that's how earlier Eighth Amendment decisions work. That's why after Furman versus Georgia, death penalty statutes were all invalid and had to be rewritten. Or you conceptualize it as a, whatever the statute says, it can't reach those who were minors when they committed the offense, in which case it's only unconstitutional as applied to them. Same underlying principle articulated one way or another. It seems to me the same thing is true about this proposed limitation of the Commerce Clause based on inactivity or forcing people to enter the market. One could conceive of that as a principle that says any purported congressional regulation of commerce, in order to be constitutional, must not regulate inaction. And if understood that way, it would call for, if you accept both merits, facial invalidation of the individual mandate. But you could also conceptualize it and articulate it differently as simply saying that the national government can't use its commerce regulations against those who have not engaged in the relevant action or have not entered the relevant market. If articulated and understood that way, then it would call for simply findings of as applied invalidity as to those situations where people haven't so entered the market or engaged in that activity. If that's right, if we're dealing with a principle that can be understood in both ways, how does the court go about deciding between them? Well, one method that seems to be in play, at least at an intuitive level, is simply a sense of how great a proportion of the total likely applications of a statute are the unconstitutional ones. But is there anything else besides this sense of proportion? I think so. I think there are three, two that I've noted before, one that builds on the insights of Richmond's own Professor Walsh. Professor Walsh has challenged the near universal view that severability is the only way to understand decisions, holding that a statute can be validly applied to some cases despite the existence or possible existence of unconstitutional applications of the same statute. He argues that a better metaphor than severance is the metaphor of displacement, so that instead of cutting things out, we should envision layering things on top of each other so that the higher law displaces the lower law. I think there's a lot of power to Professor Walsh's image. I think that it helps us assimilate constitutional adjudication to all other adjudication that courts must decide between two conflicting laws, two statutes, statute and common law, statute and treaty, federal law and state law. come up with what the relevant rule of priority is, and then apply that law that wins under the rule of priority. If we think about constitutional adjudication that way, as not different in kind from all other adjudication, that may, I think, pull us more in the direction of seeing law as a whole, state and federal, administrative, legislative, judicial, statutory, constitutional, as all of one piece, rather than the judicial decision-making in the constitutional area being courts with either exacto knives or meat cleavers cutting things away. And I think if we think of law that way, we'd be less inclined to sort of demand tests that look to facial invalidity. I've also argued that legislators and presidents would probably have to deal with bills as a whole, while courts look at individual applications of individual provisions, that courts have a comparative competence in as-applied adjudication, and therefore they should shape constitutional doctrine to take advantage of that comparative competence. And finally, I think that there's another reason why courts should, where possible, create doctrine that pulls toward as-applied adjudication rather than facial adjudication, and that's because doctrine that fosters facial adjudication, that fosters winner-take-all, up or down facial determinations, isn't necessarily a method for more vigorous constitutional protection of whatever value is being enforced, but instead simply raises the stakes, while creating doctrine in a way that leads to as-applied determinations lowers the stakes. And at least to me, particularly in a hyper-polarized political environment, raising the stakes seems unwise. Thank you.
Good morning, everyone. My name is Toby Dorsey, and I've been asked to talk about severability. I must confess that when I was asked to do this, I wasn't sure that I should. I don't really like getting up in front of people. I like to work across a table from them. I work with 7 advised and consent commissioners. 3 of them are federal judges, and I'm much more comfortable sitting around a table and talking to them face to face. But I'll do the best I can. At first I wasn't sure I was the right person to talk about this, but the more I thought about it, the more I realized I might have a perspective that might be useful. I work at a federal agency that has a rather special relationship with severability, the United States Sentencing Commission. In 2005, in United States v. Booker, the Supreme Court ruled that the mandatory guideline system set up in the Sentencing Reform Act of 1984 was unconstitutional and severed part of our statute. And as a result, the sentencing guidelines are no longer mandatory on federal judges. They are now advisory. It was a small step in the sentencing process, a small change, but for us, it was a giant leap. And we're still adjusting to that. But I think the real reason that I was asked to speak is because I spent 10 years working on the Hill for Congress as a legislative drafter in the Office of Legislative Counsel of the House of Representatives. In doing that, I developed a perspective about the way laws work, the way Congress should operate, the degree to which the courts should look at political bargains in deciding what to do when they interpret statutes and what to do when they rule on severability. I personally have advised clients on severability hundreds of times. At the Office of Legislative Counsel, we have a drafting manual, and this actually surfaced in the 11th Circuit's opinion. We have a drafting manual that advises us to advise our clients that you don't need to have a severability clause. Severability is the rule under the Supreme Court precedent. You may need to consider a non-severability clause if there's a desire for your clients to have a particular set of provisions all stand or fall together. The Affordable Care Act does not have either a severability clause or a non-severability clause. And Judge Vinson at the trial court level had ruled that the severability clause, the lack of a severability clause was fatal and made the entire act unconstitutional, the entire thing. And the 11th Circuit pointed out that there in fact, congressional practice is consistent with Supreme Court precedent in saying that you don't need to have a severability clause at all. The views I'm going to share with you are my personal views. I don't speak for the Office of Legislative Counsel. I don't speak for the Sentencing Commission. But I do have some things that I'd like to say. The idea that statutes are based on legislative bargains and that the court should simply identify the bargain and the severability decision will flow logically from that is really troubling and fraught with peril and very, very difficult to apply. And in the Affordable Care Act legislation, we're seeing that. The trial court in the Virginia legislation said that, Judge Hudson said, we have no idea how to apply this test, basically, in the context of the Affordable Care Act, and we just don't know what to do, and so we're just going to presume severability and strike as narrowly as possible. But this actually happens in every case. Every case when severability is considered, the courts throw up their hands and say, we don't really know how we're supposed to identify which provisions Congress wanted and which provisions Congress didn't want to be severable. We don't know how to do this. The fact is that a statute is not the result of a legislative bargain. It's the product of a convergence of micro-bargains between and among 100 senators, 435 representatives, and the White House. And there are trade-offs made within single provisions, but there are also trade-offs made with other provisions in the bill. Trade-offs are also made between this provision and that funding provision. Trade-offs are made between this bill and that bill, between this bill and that nomination that's important to you, between this bill and that decision not to promulgate regulations or to promulgate regulations or to make a grant or to provide an earmark. There are people who feel that they can pore over the legislative history or pore over the statute and confidently identify the legislative bargain. And I suggest to you that they're probably also confident that they can look at a sonar image of Loch Ness and they can confidently tell you, yes, that's a plesiosaur. But I think that there are dark shapes in the water, okay? And I'm not really sure that we can really do more than that. I'm not really sure that the judiciary should be doing more than that. I know that many people care one way or the other about healthcare reform and how, as a policy matter, how this turns out. And the earlier panel this morning, there was some talk about so many people are jumping into this litigation for political reasons and because they're interested in it as a policy matter. Some people may think it's a great idea, and some people may think it's a terrible idea. And good for you. I'm not one of you. I really don't care about healthcare policy. And that's part of the reason why my instinct when I was first asked about talking here was that I turned it down. Healthcare policy, I don't care. But then the thing is that the work that you do as an institutional servant of Congress is it's best done by someone who doesn't care about policy at all and cares a lot about the rule of law. You work with a wide range of people with a wide range of policy views, and your role is to help everyone. What I cared about wasn't the merits of your idea, but what I cared about was how well has this been thought through? Not in terms of whether it should be done or should not be done, but what are the implications? So, for example, if you came to me and said, Toby, my boss, he ran on a platform of a chicken in every pot, so can you give us a bill that'll put a chicken in every pot? Now, that kind of question happens not infrequently, especially in the House of Representatives. And you have to say, okay, fine, what kind of chicken? And what kind of pot? And is it really one chicken per pot, or do you mean one chicken per citizen, one chicken per household, one chicken per person? how is this going to really work? Who's going to deliver the chickens and when and how? And where's the money going to come from? And is someone going to be liable for negligently delivered chickens? And are we going to do this every year, or are we just doing this one time? And by the way, have you thought about whether this is based on the Commerce Clause or the Spending Clause or the Necessary Profit Clause? Because at some level it needs to be based on one of those things. But I don't care about chicken policy and I don't care about healthcare policy, but I care about the rule of law. And in the severability context, to me that means letting the policy-making branches do their work, letting the judicial branch do its work, and letting the rest of us go about our business and make our plans with as little legal risk as possible. We don't have that now. The Supreme Court decides what needs to be stricken for constitutional reasons and then asks what else it should strike for political reasons. The ordinary rule is that judges do not decide political questions. And for good reason, judges are not qualified to do it. And the judicial branch as an institution is not supposed to do it. We have 9 justices on the Supreme Court, and with all due respect to the several months that Justice Thomas spent in Senator Danforth's office and the approximately a year that Justice Breyer spent on the Senate Judiciary Committee, they have no idea how the legislative process works. I mean, they do in the civics sense, but they don't really have an understanding of the pragmatics. So let me tell you the story of Public Law 98-473. This is from 1984. This is the Sentencing Reform Act. It provided funding for several federal departments. It passed the House on September 25, but only after a comprehensive crime bill was tacked onto it. It moved to the Senate, dozens of amendments. On October 4, the Senate passed it and sent it back to the House, but the House rejected it. A week later, there was a final compromise. It passed Congress on October 11 and was signed by the President on October 12. During all this time, government was in shutdown. Everything was being passed, a series of 24-hour extensions, continuing resolutions. Most federal workers were furloughed. On October 5, there was a continuing resolution to fund the government until 6 o'clock p.m. the following day. Government went into shutdown after that. There was a resolution enacted the following morning to fund it for another day. It went into shutdown after that. In this kind of environment, there was a lot of pressure to put some kind of crime package together with some kind of funding package that would work for the White House and would work for the House of Representatives. The funding part enacted a lot of things. It made possible federal agencies to contract with state and local governments for firefighting services. It required the federal office to keep statistics on metropolitan areas to stop dividing Greater St. Louis into 3 different areas. Instead, use one area. The crime package did many things. It changed bail procedures, it changed sentencing, it eliminated parole, it made it easier for the government to seize profits from illegal activities, and it made it harder to establish an insanity defense. This was President Reagan's crime bill. It was in the news just recently that John Hinckley was, there's an issue about whether it's time for him to be released. And it was because of the Hinckley assassination attempt on President Reagan that he wanted this tough crime package. All of it came to pass because of convergence of interest. The Democrats wanted some things, the Republicans wanted other things, the President wanted something else. And more or less what happened in the end was the Democrats in the House agreed to accept the Republican crime package to get more, and got more funding in return, more earmarks in the districts that they wanted to. Well, it turns out, 20-odd years later, that there's a problem with one sentence of this 400-page bill. There's a provision that says that it's the sentencing guidelines provision, and it says that judges have to impose a guideline sentence. And it turns out that violates the Sixth Amendment right to a jury trial. No one had any idea of this in 1984. No one had any idea of this in 2000, when this whole line of jurisprudence even began. There was a court decision called the Queally v. New Jersey that changed Sixth Amendment jurisprudence in 2000, 16 years after the Sentencing Reform Act. And 5 years after that, it led to a finding that the sentencing guideline system was broken too. There was a law review article written by Dean Tom Campbell in the Hastings Law Journal in July of this year. He called for the entire abolition of the doctrine of severability. He said basically, if there is a flaw, constitutional flaw in a statute, then as a matter of constitutional law, respect for the coordinate branches, the entire act that has this piece, this problematic piece, needs to be sent back, needs to be stricken and sent back. How do you do that 21 years later? How do you do that when that happens? That's certainly not what you can do in the context of the Sentencing Reform Act. Many of the provisions in the Sentencing Reform Act and in the rest of that public law have been re-amended many, many times. Congress has revisited them, has reconsidered them in other big acts, and has made changes. How do you? They're layer upon layer, like an old New England stone wall. How do you figure out what you tear out of the statute book? I mean, yeah, you tear out everything from 1984, but what about everything else? Do they stand or fall? Under his logic, I think they would all have to fall. I don't think this makes any sense. He says it looks like that the ability of a judge to just take a blue pencil to an act looks like a line item veto, and therefore it's unconstitutional. But to me, it looks like to me, his idea looks like an unlimited judicial veto. In fact, it's even better than the one the president has. All the judges have to do, get 5 judges together anytime, this term, next century, find something wrong with one sentence in a 400-page bill, strike down the whole thing. No ability of Congress to, by a 2/3 majority, to override. It just happens. Just 5 judges get together and boom, it's all gone. That's kind of what's happening in the Affordable Care Act controversy. There's an argument made. Granted, it's a different posture because with the Affordable Care Act, we are just, things have just begun to be implemented. And we're not in a situation where 21 years later, things are different. But why should the constitutional analysis change? Why should the constitutional analysis change just because of the passage of time? If the entire thing must be struck now, then the entire thing must also be stricken if there's an unconstitutional provision 21 years from now. There shouldn't be any difference. And yet, somehow, it seems like somehow people seem to think that there should be. Let me talk about the real reason I think that Dean Campbell is hung up is because he actually thinks that when there is a judicial striking of a provision, that something is actually being stricken from the statute books. But that doesn't happen. The provisions that are being stricken are not actually being stricken. They're still there in the books. It's just that there's a judicial holding that they can't be enforced. So there's not really, the comparison is not really apt. And to speak of striking and blue penciling is really very misleading. What we're talking about here is the Article 3 power, not some line item veto. We're talking about the Article 3 power to hold something unconstitutional. And it seems to me that if you're going to hold something unconstitutional, then hold it unconstitutional and don't do anything else. That's the narrowest way, the most judicially restrained way that you can do something. This is not like statutory interpretation. This is not like severability of a contract provision where there are bargains between parties. We're talking about something that Article 1, Section 7 went through that process, was passed by both chambers, was presented to the President, became law. And now the question is, what do we do about this one small problem in this one part? And yes, things can be tied together politically. They can be tied together for policy reasons. But those are different from constitutional reasons. And the current doctrine that the court uses is to apply a test that first strikes as narrowly as possible, they say, but then looks and says, well, what else should we strike here while we're in here? kind of like your surgeon who's cut you open and says, okay, I'll fix your knee. What else should I do? Gosh, I think you want me to do these other things too, so I'll do them as well. That's not the way constitutional law is supposed to work. The fact is, there's a lot of talk about how we need to honor legislative bargains, and lawmakers have access to counsel, me, other people. They know where the legal risks are, or where they could be. Granted, no one knew the legal risks of what happened in Booker in 1984, but and if they bargain for a provision that turns out to be unconstitutional, they assume that risk. That holds true not only for individuals, but for lawmaking institutions. If the political branches bargain with each other to create a legal regime that has a constitutional defect, equity is not on their side, and the court should not play politics and honor the underlying political bargain. That's really nonsense. That's putting legislative relations into the arena of constitutional law. There are people who object to legislative history, and I'm one of them, for similar reasons, but this takes the whole legislative history analysis to another level. It's one thing to consider information about what lawmakers intended when deciding how to read a provision that is fully constitutional, and quite another to rely on speculation about what lawmakers would have intended when deciding whether to strike a provision that is fully constitutional. I'm very happy to speculate about how the House and Senate would have voted on a bill if provision Y were not part of it, but that's for a parlor game or an internet chat room, and it's not for constitutional decision-making. There have been a series of cases. I'd like to speak very briefly, with the time I have left, with my 2 minutes, about what I think is going to happen with the Affordable Care Act. All 7 of the justices who have ruled on severability in one way or another, the 2 most recent ones have never done it, but all 7 have ruled in 3 or 4 cases now that what the court will first do is it will strike as narrowly as possible. Generally speaking, they'll strike as little as possible. But then they will say, what? Well, we then ask whether it's evident that Congress would have enacted what remains. If it knew that the stricken provision was stricken. They always end up asking that question. They very rarely actually invoke that. They very rarely do. And what's unusual in the Affordable Care Act litigation is that the government is actually asking them to strike down not only they're not asking them to strike down the individual mandate, but they're saying if you strike the individual mandate, then you also have to strike 2 other things. You have to strike the guaranteed issue provision, and you have to strike the rule about whatever it's called. There are 2 provisions that you have to strike. And I have to say that I think that the government's argument is going to resonate with the Chief Justice. And the Chief Justice, I think, would be the one who would be writing this. He would be writing the decision on the merits, and I think there would be a different split among the justices about severability, and I think that he would be writing the severability decision as well. And I think it would resonate with him, because there is a provision in the statute that it's this finding on. It says basically, the individual mandate is essential to an effective healthcare system that includes these other provisions. And this is not. This is the kind of thing that I think would. If this isn't good enough, then I don't know what is. If this isn't the kind of evidence that the court says you need to have to show that something should be severable, then I don't know what they could want. I don't think that they should go down that road. I think that the whole idea that we look at the political equations is very troubling. But that's what they do. And so I would predict that if they do get to the severability decision, that they will strike the individual mandate and they will sever those other 2 provisions. And I'll be happy to take further questions about this later. Thank you.
Question right away.
Well, this is for Professor Hartnett and Mr. Dorsey. It seems to me I see sort of a commonality in your comments, and that is, and I wonder if you like your observations on this. It seems to me that in a sense both of you, the comments are building on or tracking the distinction between what I call judicial supremacy and departmentalism in terms of the role of the court in constitutional implementation. There's another way, what Bick will call the Lincolnian tension. Lincoln famously said, Dred Scott, that courts decide particular cases, and the courts also then those cases become precedents for future cases. And I would never try to take Dred Scott from his master, but I think if I were in Congress, I would keep voting the Missouri Compromise through, and you just have to keep striking it down. Are these problems you're pointing to, both facial and as applied and severability, ones that grow out of a judicial assertion of a power to go beyond deciding a particular case, anticipate future cases, and sort of have an actual legal effect of resolving them before they're even brought?
I don't think they entail each other, but I think there's a certain family affinity and consonance. That is that the more you think that the reason we have courts is to tell us what the law is, that that's why we have them, we need to have an authoritative pronouncer, then the more we tend to think, well, facial decisions are great. We get a big decision quickly. The more you think that the law announcing function of courts is simply a byproduct of their duty to decide the case, which I think is the right and the classic view, then the more you tend to think that what judges should be doing is be more focused on the case, the individual case, be less concerned about the broadest kinds of pronouncements. I don't think they necessarily. I think you could have one view. I don't think they are so closely connected that they logically entail each other. I do think that people with one approach to judicial power will tend to pull in one direction or the other.
I think I agree. The issue to me is how broadly should a judge rule on a case. And in my view, our system is designed to have judges rule on particular cases. They rule on particular cases that, in fact, they have to have a case of controversy in front of them. There are all kinds of troubling aspects to the idea that you write down a whole act. One of them is that, I don't want to talk to you, but one of them is that you're in a situation where the judges would be striking down provisions that where you don't actually have a party standing raising them. I mean, there's a provision in the Affordable Care Act that required the Sentencing Commission to raise penalties on healthcare costs. And we did that. We've already done it. We got that. We got a directive from Congress in the Act, and this past April we promulgated new guidelines, and it's effective on November 1st. We've done it. But no one understanding the current controversy raise any problem with that. But if the Act falls, then I think our guideline falls too, because it was promulgated based on that authority. I think that's very problematic. It's very problematic to have judges deciding things so broadly that there wasn't an issue that was litigated by the parties who had standing in the case.
If I could just one quick point. To my mind, the silliness of thinking that because you find one application of one provision of the statute, the whole thing must fail. The other silliness of that, to me, is illustrated by Marbury. Right? Marbury finds one application of one part of Section 13 of the Judicial Act of 1789 in the Constitution. If you say because you found that, therefore the Judicial Act of 1789 falls, the Supreme Court has to go out of business. The only possible basis I can imagine for adopting this view is if you are really hostile to judicial review and you want the interim effect.
A question here in front.
So I have a question for Professor Walsh. I thought in Judge Silverman's opinion about the anti-injunction, I'm sorry if I'm getting into the weeds a little bit, his procedure. One of the things that that I saw he raised that I hadn't seen to this point was that the IRS, well, the federal government has taken the position that the anti-injunction does not apply, at least since it got to the federal circuit level. And he said that position under administrative law principles is entitled to some deference, which would be a procedural way for the Supreme Court to get out of the procedurally difficult questions, right? To just say, well, it's a reasonable position. I'm wondering if you have any view on whether Skidmore or whatever level of deference is appropriate to the federal government's position with respect to the applicability of the AMA, or instead, because it's a jurisdictional issue, it's outside the scope of the normal deference doctrine.
I didn't see the authority for that level of deference, and I thought one of the most effective parts of Judge Kavanaugh's dissent was his pointing out of the separation of powers problems with deferring to the executive here. If we think of this as a directive from Congress that no suit shall be maintained, this isn't really interpretive deference, right? There's no question about no suit shall be maintained. I mean, no suit shall be maintained. No. As long as we're within it, and then it's a sort of, do you defer to the interpretation of the Affordable Care Act and what it means there? But I wasn't sure what he was deferring to, other than the government's litigation position, rather than anything else. And so I think it's troubling if Congress, which has the power to regulate federal court jurisdiction, if those can just be not quite waived, but in statute-specific ways just taken out. And so I disagree with it, but I'm sure Judge Kavanaugh, I would defer to Judge Kavanaugh's explanation, and I think that's appropriate deference.
So we have a question in the back, right there in the middle.
Yeah, well, since we're sitting in a business school, I want to try and broaden the discussion a little bit, thinking of the real world and business world. We certainly hear a lot of comments these days about the problem with job creation in our economies is we don't have predictability. Of course, you're usually pointing to figures of regulators. I don't see anything different these days than the olden days with regulators. But I've always thought in terms of judicial decisions, part of the problem we have is decisions are too narrow. But the problem with judges, I guess, sometimes going on broad decisions is they fail to think of things all the way down the line just because parties haven't presented them. Isn't the best solution to have broad decisions, but make sure you thought through all the implications down the line of that broad decision, and then doesn't that provide society and business with more predictability?
Take that in the first instance. It's not surprising that when Virginia was seeking cert before judgment, right, to say, look, we need to know. Greta Van Susteren interviewed Donald Trump, and Donald said, we need predictability, right? So what's the problem? What's the problem here? And I think there are circumstances in which that's appropriate. However, I think the system that we have has worked pretty well so far, and so this is more of just a sort of don't tinker with it. It is sort of my own inclination. On the Anti-Injunction Act, though, in particular, I think the reasons you articulated about the need for certainty would justify both Democrats and Republicans to craft a specific exception, do it by statute. I've been told this is politically unrealistic, so such as it is. Although I will say it's been I think the general idea that the Supreme Court needs to decide this has been decided by both, in particular, both Democrats and Republicans alike. The federal government moved forward its response. They could have slow-walked this much further. They could have sought en blanc, and so who knows? But it should be, if we're talking statutory subject matter jurisdiction problem, then take it to Congress. Let them take responsibility for this particular thing. As to case or controversy, I just say it's not negotiable. Period.
So let me also respond to that. Absolutely, we should have more certainty, we should have more clear policy, and the policy-making branches are the Congress and the President, not courts. Courts should not be making policy. So.
I have a question then, seeing no hands. It's a bit of a follow-up to the question that was just presented, and I think I'll direct it to Professor Hartnett, but if others have a view, should please chime in. Professor Hartnett, your view seems to suggest that as-applied challenges are sort of an appropriate, modest posture, given the other institutions that may have an interest. But I think a close cousin of the facial and as-applied doctrine, or at least functionally speaking, might be the rules and standards debate. And in the rules and both debates talk about whether we rule on one case or many cases. Rule in Miranda applies to a whole bundle. And in that debate, I think there's a bit of a tension. Justice Scalia, for instance, says we should prefer rules because that restrains judges and that's modesty, right? So he would say we want clear rules. That's how we get modesty, or that's how we set up a system of modesty. That would seem to sort of push in favor of facial challenges, or at least facial rulings. Do you see a tension there, or is there a distinction?
No, I think I acknowledge that there's some tension there, and to the extent that that the desire for relatively all-encompassing rulings doesn't map on necessarily to decisions about how much to be deferential to elected and unelected branches, because you have these sort of cross-cutting concern, such as you've articulated. I guess it seems to me that it's worth distinguishing between a doctrine that calls for as applied adjudication that nevertheless applies to lots of cases, but calls for fact-specific determinations in those cases, as opposed to a doctrine that says we don't care about the particulars of this case. What we want to do is find a particular provision invalid across the board. So I acknowledge some tensions there, but I don't think that they're exactly the same thing.
Anything else? Sure.
Maybe I'm just picturing your arguments or putting this too simply, but I guess my question is just Professor Walsh and Professor Hartnett. But the way I'm seeing it is putting aside your argument with Professor Walsh that no one has standing to sue if it's enforced under the Tax Injunction Act, aside from the states and aside from it that were to take away individual standing. So assuming that someone did have the right to sue, I guess I can somewhat see maybe some kind of intersection between Professor Hartnett's act, that if you're going to argue that the statute should be as applied, that's when you get to the notion of the remedy, because you can see the whole thing together in the way that you were arguing. Do you see any kind of consistencies in your arguments there, or do you think they totally tend to oppose each other?
I think they're clear. Yeah, it's a good question. I think that they're definitely related, right? Because why I think it's important to focus on the Anti-Injunction Act, regardless of how it ultimately gets decided, is because it forces us to recognize that what courts are being asked to do is enter judgments and then issue remedies that have particular effect. And I think then when we are in that focus, we can say how broad, how narrow ought the ruling to be. I think it's a distinct question, though, as to how you craft the substantive doctrine and whether you want those to be broad or narrow. And this sort of leads into the question that I had about the possibility of crafting an as-applied ruling given Gonzalez versus Raich. So when we have, because I personally would like to see it done, I think, but I'm not sure how. So the court says we will not excise as sort of trivial instances or something like that, and will it be? But we will excise if you've never acted or something like that. How does it go? Because I'd be interested.
Well, I mean, there's no doubt that given the trajectory of Commerce Clause doctrine, it is hard to say let's treat this as applied rather than case. But this is why I think it's important that what's being asked for on either side is new doctrine. So that when we say, look, in the substantial effects comments, what we're saying is there a substantial effect on interstate commerce? We're not going to let you say, oh, my contribution is really little, and therefore it's trivial, and therefore I get an exemption. But now, if you buy on the merits, and you may well not buy on the merits, but we're bracketing that. As soon as you buy on the merits, the idea that there's a categorical difference between saying we don't care about how trivial your contribution is. If you're not contributing at all, if you have not done the relevant action, if you haven't entered the relevant market, Congress can't make you enter that market. We're not talking about a new doctrine with a conceptual line. And to say, we're not saying the law can't be applied to you because you have a trivial impact on interstate commerce. There may be an impact on interstate commerce by your inaction, by your non-decision. But we have a new categorical rule that says Congress can't reach inaction. Congress can't reach people who haven't taken some relevant action in the relevant market. And if you find somebody in that category, the statute can't be validly applied to them. But as everybody else, it can be validly applied. I think because we're talking about new doctrine, we can carve out the substantial effects aspects of rigor and range.
So, because in other contexts of congressional power, they do something like that. Bernie's an example, right, where congressional power isn't all or nothing, or United States versus reigns, or some of these cases. So you'd say that Lopez, Morrison, going back really to Jones and Laughlin, those are substantial. That's your substantial effects test under the Commerce Clause. But for other areas of Commerce Clause analysis, you're not bound to look at it through that frame. Is that true?
Right. Again, I'm not, because we're not talking about outside merits. I'm not saying the court should adopt this principle on the merits. I'm saying if the court adopts this principle on the merits, to my mind, it is better articulated as an applied limitation, and we're not precluded by the older doctrine, which wasn't addressing this conceptual difference.
We're about out of time. Actually, we are out of time. So those of you with burning questions will have to storm the dais. Join me in thanking everyone. Please join us for the third session later this afternoon.